Alright folks, buckle up. What you're about to witness is more than a routine court hearing. It's the unfolding of a second-degree felony plea. Possession of a controlled substance. Penalty, Group 1. That's serious time. Think 2 to 20 years and a $10,000 fine. Let's see how Christina Garza navigates this legal tightrope.
Counsel, have you received all discovery? Did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Ms. Garza, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the repeater enhancement.
Any objection?
No objection from defense.
All right, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of possession of a controlled substance, penalty group 1, 4,200 grams, that's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am. Sorry. I distracted her, Judge.
That's okay. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a...
Did you catch that? The judge is walking the defendant through a constitutional checklist. Right to a jury trial. Right to remain silent. Right to confront witnesses. This isn't just formalities. Waiving these rights locks in the plea and shuts down most paths to appeal. High stakes, high pressure.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Quick check-in. This is what we call a plea colloquy, a courtroom ritual where the judge ensures the defendant isn't being coerced or misled. If the judge gets even a whiff of confusion or fear, the whole plea deal could crumble. But here, Christina seems sharp, prepared, and determined.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 6 years. There be 200 hours of community service restitution, TAP evaluation, no contact with Miller Park or 2802 MLK Drive, and the moral recognition therapy course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Yes.
State, any evidence?
State offer states 1 in attachment.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Okay, here's the big moment. The evidence is in, the stipulations are signed, And now the judge decides whether to accept the plea and grant deferred adjudication. Translation: no conviction on record if Christina follows the rules. But one slip up and it's straight. 2 sentencing, no reset button.
After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, we waive PSI.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client has been a drug addict since she was 15. She hit a rock bottom, and we've submitted evidence to you that she voluntarily submitted herself to drug treatment. She's submitted a hair follicle test as of May 2025. And if you tested her today, she would test absolutely clean for absolutely everything. That includes marijuana, that includes THC, that includes CBD. She is rebuilding her life. And
now we hit the heart of the story. Reunification with her child. That's not just emotionally gut-wrenching, it's legally complex. CPS therapy mandates years of separation. Christina's not just fighting for her freedom, she's fighting to be a mum again. You can feel the courtroom tension spike here.
She believes that she will be successful on probation because of the commitments that she has made to both herself and to her family. And she really has already seen the success of making those life changes. She is in a part-time program through which college? I'm sorry. SNHU for substance abuse counseling. And she has a full-time job, and she is on a road to reunification with her child. She fully believes that she'll be successful on probation because of the choices that she made voluntarily, and has seen your rulings in the court and the conditions that you've required of people, and know that she can be successful in this.
All right.
And we actually submitted to you with
I have those. Yes.
And here's the twist. Current job is technically off limits under standard probation rules. Why? Because working around vulnerable populations like minors or elderly patients while on felony probation is a massive red flag. But the judge, she's open. If Christina can prove her trustworthiness. Talk about walking a legal tightrope.
All right, this is what the court is going to do. There's a $2,000 fine that will be probated. 4 years deferred adjudication. Proof of employment within 30 days. No employment as a home health care provider or with minors. There is to be 200 hours of community service restitution. I'm going to order parenting classes. If you provide proof that you've completed it within this year, then the court will count that as your parenting classes. You understand? So how far did you go in school?
I got my GED.
All right, so what is your goal in life?
I have a full-time job.
All right, doing
We'll
what?
address that in a second. We'll address that. I know you're freaking out.
Yeah.
We'll address it in just a second.
So what do you want to do with what is the big picture? What is your dream job?
I'm going to be a substance abuse counselor. That's
All
what
right.
I was going for.
So the court will deduct 100 hours from the community service restitution once you provide proof of completion of parenting classes. The remaining 100 hours will be deducted if you obtain some type of trade school certificate or certification in your field of choice. There's to be no contact with, have you had any contact with Elizabeth Rios?
No.
All right, so there's to be no contact with Elizabeth Rios or Miller Park or 2802 MLK Drive. There's to be regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 6 months. Probation, is there anything else? All right, is there anything else you need from the court in order to be successful?
Yes, Judge. And so she does work as a home health care provider. She has worked hard to get this job. I understand. She's worked hard to get this job, and a part of her ability.
Let this sink in. If Christina ever feels on the verge of relapse, All she has to do is call her probation officer, and instead of punishment, she gets help. That's a bold, compassionate model. But here's the catch: silence equals consequence. Communication is her lifeline now.
To be successful in her sobriety has been the ability to provide for herself and hopefully pay for this reunification. With permission of her patients, will the court allow her to continue working?
I will consider it, but you have to get a letter from whoever you're caring for. And that letter has to let them know specifically what you're charged with, what you're on probation for. I'm not saying I'll do it, but I'll consider it. And I'm definitely not going to do it if the state is not in agreement with them. Because one of the things, my job is to protect the community, and being around vulnerable persons when you have felonies, that's tough for me. So usually no employment